will start with our topic for today. Um, it's called Violence Against Women and Children. Okay. So the law that it is based on is called Republic Act 9262. So I think at one point or another, you may have heard of this law. I want to give a short background on 9262 because actually a law that I am quite proud of. It is landmark legislation in the Philippines because it is a law for women, and and women were instrumental in having this law passed. One of the backgrounds as to why there was a need for this law is because of state policies in our constitution about upholding the dignity of children and women and protecting the family, especially women and children, to ensure their personal safety and security. Also, the Philippines is a signatory in the UN Convention for Protection of Women and Children. So, as part of our obligations under that treaty, numerous women's groups lobbied for this law. It was finally passed in March 2004, and you will note that even the people who authored this law are women. So, first the Senate, it was Dr. Loy Ejercito. For the Congress, it was Congresswoman Bella Flor Angara Castillo. And it was also passed into law by a female president, President Gloria Macapagal Arroyo. In fact, in the ASEAN, RA 9262 is deemed one of the most progressive laws in Southeast Asia. There's actually nothing similar or that comes close to it. I mean, it is not a perfect law, but it is more than what our neighbors have at the moment with respect to protecting children and women. And I remember there was an earlier query as to why it only protects women and children. It's precisely because of that UN treaty that recognized that certain acts of violence or certain criminal acts are gender based. It is a gender sensitive criminal act that you won't typically find a woman doing against a man or a child doing against a grown man. So that's why the scope of the law is very specific, very limited. So the next part is, so you know how the law here is always so very wordy. So I'll give you first a big definition, which we will take apart because this definition in itself actually uh, basically summarizes the entire law. I find it very smartly worded because let's start with it is any act or series of acts committed by any person against a woman who is his wife, former wife, or against a woman whom the person has or had a sexual or dating relationship, or with whom he has a common child, or against her child, whether legitimate or illegitimate, within or without the family abode, which result in or is likely to result in physical, sexual, psychological harm or suffering, or economic abuse, including threats of such acts, battery, assault, coercion, harassment, or arbitrary deprivation of liberty. Now, this VAUSI is a public crime. So why do I have to make this distinction? This means that VAUSI, if it's a private crime, only the victim can file a complaint. But since VAUSI is a public crime, any person who has personal knowledge of what happened can file the complaint for the victim. This is especially important in the case of minors or in the case where the abuse is physical abuse and the woman is too scared to come forward or entirely dependent on her husband. Any person with personal knowledge of the circumstances of abuse can file the case for her, and when it reaches the court, since it is a public crime, it is prosecuted by our public prosecutors. Right? So, by way of example, other public crimes include adultery and concubinage. So, these are crimes against chastity. So, like VAUSI, these are public crimes. Now, who can commit VAUSI? Going back to the definition earlier, the definition mentioned committed by any person. So, whether it be your current or ex-husband, live-in partner, boyfriend or girlfriend, or sexual or dating partner. So you'll notice there's a distinction between the boyfriend and girlfriend relationship and the sexual and dating partner. So the perpetrator may be a man or a lesbian woman. Why does the law distinguish that it has to be a man or a lesbian woman? Because of the reality that there are homosexual relationships, but then why exclude gay men? Because again, it's still a gender specific act that you are protecting. It's a gender based act. So uh, a lesbian partnership, a lesbian live-in partner may be held liable for vowsy. So I often get the question, what about gay men in long-term relationships or short-term relationships and abuse? Let's be realistic because abuse also happens in homosexual relationships involving two men. Unfortunately, hindi sila pasok sa batas. So the remedies will be under our revised penal code, but not under VAUSI. So next, again, the victim is always a woman or her children. And when we say children, we are talking about children who are 18 and below. So who are the victims? It says here, it says any acts or a series of acts committed by any person against. So when you say, again, the law is very clear. So it can be one act or it can be a series of acts against, as enumerated earlier, a woman who is his wife, a former wife, a woman with whom the person, and so when they say the person, it can be a man or a lesbian partner, has had or has sexual or dating relationship, a woman with whom he has a common child or the biological child, and against a woman's child, whether legitimate or illegitimate. In other words, any woman who has
Excuse me, attorney. We cannot hear you.
is taking care of. Can you hear me now?
Nag-choppy ka kanina. Yes.
Okay. So there, when you say the last part against a woman's child, whether legitimate or illegitimate, it can be any child over whom the woman has care and custody. So it can be a relative or it can be someone that she did not formally adopt, as long as the woman, the child under the woman's care would qualify as a victim under this law. So next we go to what is a sexual relationship. So the law defines sexual relation. So this can mean a single sexual act, which may or may not result in sharing of a common child. So what if it's just a fling or if it's a one night stand? This will not fall under VAUSI automatically because presumption is there's no relationship. All right. And I've one of the questions I always hear also is what if in some instances in the Philippines, for instance, you have men who have sexual relationships with prostitutes. What if the prostitute gets pregnant or demands economic abuse under VAUSI? It it doesn't say so in the law, but case law provides, or cases of which the Supreme Court has ruled on, prostitutes in this instance will not be able to claim that kind of relief from VAUSI because the presumption behind a dating or sexual relationship is the relationship, whereas any relationship with a prostitute is deemed as a paid transaction. So even if, because and it happens in our society that a man has a relationship with a prostitute, even if he's married, the prostitute, because of the inherent illegality of her profession and the fact that she is paid still, whether it be in kind, property, or money, will not be able to claim VAUSI. Her remedy will be elsewhere. So next. And what is a dating relationship? So when a situation wherein the parties, again parties, so it can be woman and woman, man and woman, live together as husband and wife without the benefit of marriage, are romantically involved over time and on a continuing basis. Again, so hindi pwede fling kasi it has to have a certain, the law does not define the period, but kumbaga it has to be continuing. So this means casual acquaintances or ordinary socialization between two individuals in a business or social context is not a dating relationship. I have a picture here of a cell phone because paano kung LDR? pwede ka pa rin mag-vowsy as long as you can establish that your dating relationship, even if long distance, because you can also have emotional abuse even in LDR relationships, di ba? As long as you can establish. Okay na. Okay na, James. So even if it's a long distance relationship, as long as you can establish continuity and it has been going on over a certain period, if there are grounds for abuse, you can still file for vowsy. Okay. So what are the acts penalized, punished as violence against women? Number one is physical violence, which is the most obvious one because you can see it. There's evidence, there's physical evidence. So these include bodily or physical harm. It doesn't have to be actual harm, but even threat of harm. Okay. It is when you place a woman or child in fear of imminent physical harm. So even just when you threaten or intimidate them, that can be vowsy. It's attempting to restrict or restricting freedom of movement or conduct of the child or the woman, which we'll expound on later. And also in instances when the man or the partner threatens to inflict physical harm on himself or herself. Because sometimes you have instances when your partner will say, if you leave me, I will kill you. I will kill myself. Or I will commit suicide if you leave me. So this threat to oneself can also be deemed actually as physical abuse. Um, Physical. So going back to use of force, um, or physical harm in attempting to compel the woman or child to engage in conduct which they have the right to desist from, such as, for example, you have a right to not do drugs. You have a right to not want to do obscene films or obscene videos. Um, and if he forces you or compels you to do that, that's vowsy. Comparison to when he attempts to compel you or actually compels you to desist or to stop doing things which you have a right to engage in, like going to school or getting a job. These are things that constitute physical abuse. So, like, I think one of the really good examples, even though it's fictional, is that movie Room with Brie Larson, wherein they were physically restricted from leaving the room, from going to school, from getting a job. So that's an extreme example of this kind of physical abuse that involves restriction of movement or conduct. Next. So going back to that are other forms of restriction of movement or conduct when they deprive or threaten to deprive the woman of custody over her child, or when you scare your child into saying, "I will take you away from your mother," or your mother lang pala. Yes, that's a physical abuse. When you threaten or use force, in all these instances, examples I'm giving, it still falls under physical abuse because the acts are committed with threat of harm or actual harm. So when you threaten or actually remove financial support or you provide insufficient financial support, or when you threaten to deprive them of a legal right, like we mentioned kanina. For example, like having a legitimate profession or working, having a business or activity even outside of your house, or when they attempt to control the victim's own money or properties, such as when you get a gift or a donation perhaps from your family, and even though it becomes your exclusive property, they still control it. Or when they have sole control over your conjugal or common property and use threat or intimidation to assert this control, it's still physical violence. So other acts are sexual violence committed against the woman or her child. So I enumerated them here. It's rape, sexual harassment, acts of lasciviousness, treatment as a sex object, demeaning and sexually suggestive remarks, physically attacking sexual parts of the victim's body. By way of example, I had a case before that the live-in partner like to parang the word that we had to use because we couldn't even describe it in English. Lagi niyang tinatapik yung breast ng partner niya constantly like that. It's a form of sexual abuse. Forcing them to watch obscene publications, indecent shows, or forcing them to do pornographic films or acts. Another form of sexual violence is when you force your wife and your mistress to live in the same house or to sleep in the same room with the husband. That's sexual abuse. When you use of actual or threat of force, physical harm to engage in any sexual activity, and prostitution of the woman or child, which is usually prosecuted under related laws on prostitution. So when we say threat, this means it can be directed against the woman or child, or you use threat um, against their immediate family. So, like for instance, when it's a child, you tell the child, if you do not engage in this sexual act, sasaktan ko yung kapatid mo, sasaktan ko lola mo, nanay mo. Or same with the mom. If you do not do the sexual act for me, I will hurt our child, your child, or whoever. The third kind of abuse is psychological violence. So when you say psychological, it's mental and emotional suffering of the victim. This can include intimidation, harassment, and damage to property. Hindi na sa'yo, there's still damage, hindi na sa katawan mo, pero everything else around you. Stalking, which I will go back to later, public ridicule or humiliation, repeated verbal abuse, and wouldn't you know it, marital infidelity, psychological violence. So a lot of women, sometimes when they are in annulment cases, when they are in annulment proceedings, they also file vowsy against their husbands for cheating on them. So that's why it happens. Another act of psychological violence is unlawful or unwanted deprivation of the right to custody or visitation of your common children. And again, as mentioned earlier, causing or allowing the victim to witness, not even to participate in, but to witness or to see or forcing her to watch uh, physical, sexual, psychological abuse of another family member, pornography in any form, or even abusive injury to a pet. So sometimes, diba, you see in movies how stalkers, they will hang up your dog or your cat. Diba, sa hilig nila ganyan sa mga sine. Under our laws, psychological violence yun. Lalo na if you use it to threaten the woman. So next. So I just have to go into stalking because it is also described in RA 9262, and it's actually one of the most common, very common forms of psychological abuse that a woman can go through, especially now in this age of social media. Diba? So stalking is an intentional act committed by a person who knowingly and without lawful justification follows the woman or the child or places the woman and or child under surveillance directly or indirectly, or a combination of everything as defined there. It can be committed personally by the stalker or through another person. So if you get your barkada or your cousin or whoever to do the stalking for you, it's still bousy and you're the one who's still liable, not your barkada. Iba na yung crime niya. So stalking or following the woman or child in a public or private place, even if you're outside the residence, if you are looking inside the window or hanging out, loitering in the street across the woman's house, or kahit nandun ka pa sa kanto, natatanaw mo yung bahay, it's still stalking, it's still psychological abuse. When you enter or force yourself to remain in the dwelling or property kahit hanggang bakuran, pwede ba sa property ng babae, against her will, it's still stalking. When you destroy the property and personal belongings of the child, the woman, or inflict harm sa pets, and any form of harassment or violence. Next is economic abuse. So this is the fourth, and also one of the most problematic, common but problematic aspects of VAUC. It's economic abuse when you attempt or make make the woman financially dependent on the husband or on the partner. When does that happen? When you withdraw financial support, when you prevent them from working or engaging in business, unless, of course, there are valid, serious, and moral grounds. No? Because what if the woman wants to, kunyari, be a drug dealer or wants to work in a house of ill repute or prostitution? Of course, the husband can object on these serious and moral grounds. But other than these grounds, you cannot prevent the woman from wanting to work. Actual or threat of deprivation of financial resources and the right to use and enjoy your common property or community property, destroying household property, and as mentioned earlier, when you control the victim's own money, especially in cases when they're not married, or when you're married, when only the man has sole control over the community property. And when we say community property, that's real and personal property. So how do you protect yourself? Under the law, your first remedy will be to get a protection order, which is issued by either the family court, which is the judicial system, or the barangay, which is under the local government. So two very distinct avenues yan. They offer similar protections in that they will prevent further acts of violence. They will safeguard the victim from further harm. It will hopefully minimize any disruptions to the victim's daily life and will allow or facilitate the opportunity and ability of the victim to independently regain control of her life. So there are three kinds of protection orders under the law. So under the LGU or the local government code, you have the BPO. Okay, it's the barangay protection order. It's the easiest and the fastest one, protection order that you can get. Why? For one, it's only valid for 15 days. Okay, so since it's valid for 15 days, it can only be enforced within your barangay. Where do you file it? In the barangay where both parties reside or live. Now, if you and your partner happen to be from different barangays, you can file this in the barangay where the respondent or the victim actually lives. If the abuse arises from the workplace or school, where the officer's school is located. I say it's the fastest because it is issued by the punong barangay. In the absence of the punong barangay, any barangay kagawad can grant an application for BPO. It says here on the same day of filing, under the law, you're required to do it on the same day you file your application. In theory, it doesn't happen like that, but in a lot of barangays, it does. So issued on the same day after ex parte determination. Ano ibig sabihin ex parte? Even if hindi sumipot yung kabilang party, hindi siya judicial proceeding. So even if hindi dumating yung guy at yung documents nila or yung proof nila as to grounds for issuing the BPO is just based on the application and statements of the victim, they have the obligation to issue it. Okay. The difference there is the PPO and the PPO. So the PPO or the temporary protection order and the permanent protection order, only our courts can do that. So it's a judicial process. Okay. The PPO is valid for 30 days unless it is extended. So every 30 days ang extension yan ng court. And it is valid anywhere in the Philippines. So the court is also required to issue it on the same day of filing after ex parte determination. So even in the absence of the perpetrator. Okay? But since it's a judicial proceeding, you need a lawyer. Kasi you file a complaint. You file a petition, an application. It's a legal document. You file a petition for application for issuance of a protection order in the family court. A family court is a regional trial court in your area that specifically handles family law cases. So usually big cities and municipalities have a designated family court talaga na family cases sa amin. Now, if they don't have that, if your place, if where you live does not have that, any regional trial court, municipal trial court, or metropolitan trial court, or metropolitan circuit court, where the victim resides, or where the crime or any of its elements is committed at the choice or option of the victim. Same thing with the PPO, because when you file at PPO, it's automatically sabay. So the court will consider it, will hear it on the PPO, but it's automatic. When you file a PPO, you're also filing for a PPO, a permanent protection order. And the permanent protection order, as the name implies, stays on forever until revoked by the court. And it is enforceable anywhere in the Philippines. The difference with a PPO is that it requires hearing. So the the family court is required to hear it on the merits. So usually the law provides that they have to hear it for everything in one day, pwede ring ex parte, pero kailangan may hearing. Unlike the TPO, na pwedeng mag-issue yung court kahit walang hearing, yung difference nun, yung PPO, kailangan pakinggan ng judge yung all circumstances. So next. So who may file a petition for protection order? Or orders, as I will explain, kasi pwedeng sabay. So, as I mentioned earlier, since it's a public crime, can be the offended party, can be your parents or guardians of the child, or even parents of the woman. So it can be relatives, ascendants, descendants, collateral relatives within the fourth civil degree of consanguinity or affinity. So pwedeng in-laws mo. Office for social workers of the DSWD or the barangay. Police officers, kasi usually may mga police departments tayo, police stations tayo na have designated women or children's desk. Also, the punong barangay or the barangay kagawad, your lawyer can file for you. Your marriage counselor can file for you. Your therapist, your doctor, your OB, your healthcare provider can provide. Nag-lump siya together. Your healthcare provider can file for you, and also two concerned responsible citizens in the city or municipality where you live who have personal knowledge of the violence. It can be your neighbor, it can be your kumare, it can be anyone who lives where you live and who has actual personal knowledge of the circumstances of abuse. So next. Now, we just have to remember that there are prescription periods. So the right to avail of the remedies under this law, they won't last forever. So when you have to apply? Within 10 years, if what you are applying for is psychological abuse, sexual abuse, mental or emotional abuse. If it's physical abuse or economic abuse, you have 20 years from the time it occurred within which to file your application for protection order. So medyo matagal. Next. So how do you apply for it? Well, it has to be in writing. It has to be signed and verified under oath. So when you say verified under oath, if it's a court document, it has to be notarized. If you're filing before the barangay, sila yung magbe-verify for you. So they will attest. You will attest in front of the barangay official, and that will be deemed as verified under oath. It may be filed independently. As I put it here now, it may be filed as an independent action or incidental relief in a civil or criminal case. So what this means is if you opt for the judicial route, you can file it independently, meaning ang pinipetition mo lang is purely the application for issuance of a protection order, or it can be an incidental relief or incident to another case. Meaning, for example, if it's a civil case, when you file a civil case for support, if you file a civil case for custody, pwede kang humingi incidental relief na vouchy. Pag criminal case, if you decide to file a criminal case separately, for instance, of rape, pwede kang mag-vouchy din kung partner mo siya. So yun yung ibig sabihin niya. And here I just summarize what the application should include. Name and address. You have to describe your relationship because relationship is important, di ba? Kasi otherwise, hindi siya vouchy kung wala yung relationship niya. So, and what you are praying for, if you need counsel, if you want if you need help, na you need a lawyer, you have to indicate that in your application para they will assign a public attorney to you, yung PAO lawyer natin. You can also request for waiver of docket fees because a lot of women actually, especially women who do not work or who are homemakers, they're afraid to file VAUSI because they don't have money. Or if the husband is controlling the purse strings, they always say, how do we file? Wala akong pera. So in that case, you can file as an indigent and you can request for a waiver for payment of the filing fees. You just have to indicate that in your application. It is automatic, but of course the court will consider that. And in many instances, the courts have granted demand's request. And also you have to attest that you have not filed any other application in another court. Note in another court that you're not prohibited from filing a BPO simultaneously with a TPO. I'll explain that later. Now, if the applicant is not a victim, which is also very common, aside from these allegations in the application, kailangan may nakakabit na affidavit. Okay? So the affidavit from the applicant, whether it's your mom, whether it's your grandma or your mother, in the case of a woman or the woman's parents, is sometimes the women are so, for lack of a better word, so banged up or so scared that they cannot bear to do the applications themselves. So their parent or their neighbor can do it for them as long as there's an affidavit and it describes the consent of the victim to file the application and again describes the circumstances of abuse. So what happens at the barangay level? Because from my experience, most of the cases in Bausi always start at the barangay level. Why? Because it's the fastest, it's swift, it's prone to abuse, and there's a lot of problems in terms of implementation at the barangay level. But the bulk of VAUSI cases always start at the barangay level. Why? Because first of all, if you report a VAUSI case, the barangay has the obligation to respond immediately to call for help or request for to a call for help or request for assistance. The barangay kagawad can actually confiscate a deadly weapon. They will transport or escort a victim to a safe place. They can even assist you or samahan ka in your house to get your personal belongings. So para silang bodyguard. And pinaka-importante, they can actually arrest the perpetrator without a warrant. That's why I said it's prone to abuse. Kasi if any of the acts are occurring in front, not in the past. So if for instance the barangay official goes to your house and the husband is so drunk or not even drunk, just doing it, continuing to do the act in front of the barangay official, or he has there is imminent danger, personal knowledge that it is still occurring, the kagawad can actually arrest your husband or partner without a warrant. Now, usually when you have barangay proceedings, the point of barangay proceedings for all other cases is for amicable settlement, correct? If you have a problem with your neighbor, you go to the barangay, right? So you can talk about everything and they will try to mediate for you. That's not allowed if it's a VAUSI case. And I've had many instances where actually it's very common. They will set the case for barangay mediation. They will set it up to 3 cases because they want parties to talk. And every time you can talk until you're blue in the face and tell them, under the law, we're not supposed to settle. We're not supposed to do this whole mediation thing. This is not barangay mediation. This is VAUSI. But they will do it. They will set it. They will keep setting and setting and setting. They will try to get the parties to talk. But under the law, it's not allowed. No amicable settlement in VAUSI. So what happens, and also, and this is a misconception because I often hear a lot of women, they ask me, Ana, attorney, pag nag-VAUSI ako, kulong yan kagad, di ba? Hindi kagad kulong yan ha, sa VAUSI. They can detain the accused if they violate a BPO for 30 days. The detention is for 30 days pala. So, hindi just because they arrest him, they can detain him forever. That's illegal detention. Under the law, detention is allowed for 30 days, assuming there's already a BPO and they violated that BPO. Okay? Bakit humahaba? And there are instances when you do hear, of men being detained in the barangay for months on end. I once heard somebody, she had her boyfriend detained in the barangay for 6 months. Imagine, ganun katagal. So, because, well, because of implementation. Sometimes implementation din ng barangay, ikakaroon ng problema. Legally, at the court level, the court may order the accused to post a bond. So this is a monetary bond to keep the peace. If the accused fails to give the bond, the court may detain him for a maximum of 6 months. So these are actually the only permissible instances under VAUC where detention is allowed under the law. Next. Next, we have the battered woman syndrome. It's technically a defense under VAUC, and it has been recognized by our courts. It's a scientifically defined pattern of psychological and behavioral symptoms found in women living in battering relationships as a result of cumulative abuse. So, under the law, this is a defense available to victim survivors. It is unique and it is controversial because it means that you will not incur in any criminal or civil liability when the justifying circumstances of self-defense are not present. Kasi under a revised penal code, under penal laws, or criminal laws, there are elements to establish self-defense. There has to be imminent threat, fear of life, fear for yourself or family member or neighbor. And for anyone to get away with the defense of self-defense, these elements have to be present. In VAUC, it excuses the woman from establishing these elements in theory. But as actually, in by way of ruling ng Supreme Court, the Supreme Court has been very wary about holding this defense. There was this famous case because even though it states there in the law na you cannot use this you cannot use battered woman syndrome as cause para if I hit or hurt my husband, I'm exempt kasi battered ako. But yung kumbaga the Supreme Court rulings have been very divided about it. My advice is don't kill your husband. If you must hit him back, huwag mong patayin. Kasi there's a case that Marivic Hanosa case, and if you read the facts, she was literally beaten black and blue every single day by her husband. But the Supreme Court still found her guilty of parricide because she ended up killing him. So even if she was provoked by her husband, even if he kept threatening her with a knife and sobra na siyang nag-snap, she was still found guilty of parricide because when she finally lost it, and the court has haba-haba ng kanilang discussion about, I understand, we sympathize, we feel sorry, we feel really bad for the victim, but the fact that he was asleep and you hit him with a pipe. So for them, they still require the existence of the elements of self-defense. Kasi wala nang imminent threat. Kasi whether lasing or nag-pass out or tulog, tapos pinatay mo, matcha-charge ka pa rin for parricide. So yun lang, hindi siya all-in na protection and practice. So other relevant provisions, non-disclosure of actual address of the victim. So like if you and your child are hiding from the guy, if you kasi diba, if you file when you file an application in court, you're supposed to put your name and your address, diba, in your application. So if someone files for you, what they can do is in their affidavit they can say this is the city or municipality where they live, and this is the mailing address. Para the specific address need not be specified for your safety. Okay, so the remedy of a BPO may be concurrent or simultaneous with the TPO or PPO, like I mentioned earlier. So, assuming may pending application ka ng BPO, or you've already been granted a BPO by the barangay, you can still apply for a TPO/PPO in court. The husband, the man, I'll get to the question later. So the influence of alcohol, illicit drugs, or any other mind-altering substances is a prohibited defense. So hindi pwedeng gamitin ng lalaki or ng partner yon. And this is funny because there have been cases, di ba kanina, the list as to who may be found liable for VAUSI is very limited. But there have been cases wherein the application for a protection order extended to other people, okay, when there is conspiracy to commit VAUSI. So there are cases like wherein the woman filed not VAUSI, because they cannot be liable under VAUSI. But when she filed for an application for protection order, the scope of the protection order included her in-laws, her parent in-laws, or in some cases, the mistress when there's economic abuse. Okay, these people again will not be held liable for VAUSI because, as we discussed earlier, the people who can be actually liable for the criminal act very specific. But pwede silang madamay in an application for a petition for protection order. So yung protection order mo can extend to your parent-in-laws, and it happens kasi in terms of physical, emotional, mental, and economic abuse, yung in-laws, lalo na if they live with the parents of the guy, or if in some cases, mama's boy, or very domineering yung parents or mother-in-law, pwedeng mag-protection order against them, or even the mistress for economic abuse. Okay? So women who are victims of violence are entitled to custody and support of their children. If the child is below 7 with mental or physical disabilities, automatic na pupunta yun sa nanay. Iba pa yan sa family code na provision, na 7 and below automatic goes to the mom. This pertains specifically to victims of violence. So if your child has mental or physical disability and there's abuse, automatic mapupunta yan sa nanay pag below 7. And another thing, if you have a pending instance, legal separation case, the problem with legal separation is that there's parang a court-mandated 6-month cooling off period, remember? So before you can file, the courts want to see what will happen before you can proceed with your case. That 6-month period will not apply if there's a VAUSI allegation. All right. So the courts will be required to hear your application or your TPO right away. No more 6 months waiting time. So next. There na. That's it. So I have a prayer here for VAUSI victims because I find that the common theme with women who experience abuse is a sense of desperation, being really lost, like you're drowning in quicksand. So I always like to refer to Psalms 143 verses 1 to 12. Actually, it should be 1 to 12. To hold on to hope, because my thing is, whether you're a Christian or not, when you're in a situation when there's abuse, you have to get out. Whether you have to get out, especially if there's physical abuse, you hold on to the Lord, you cling to His promises, but you have to ensure the safety of your person and your children. But you keep the faith. You always keep the faith. So there. We are done. So we will check the questions, I think.
Thank you so much, Attorney, for that very informative, sweet but short, but very informative discussion on VAUSI. But the first one is, I have one here. The first one is how to go about, this is in relation to economic abuse, how to go about formal child support and how to determine the amount.
Okay. So you have to make the distinction between child support that is provided under your protection order as to regular or child support that you file in a civil court. So because when you, one of the reliefs that you are entitled to under protection order is a provision as to support. Okay. So you can get that under your PPO. But again, if it's PPO, it's only valid for 30 days. And if before it converts to a PPO, you will still have to show documentation or proof as to the amount of support that you are entitled to. So it's still evidentiary if for a long time. And the thing kasi about support, even the civil case for support is always fluid. It's never permanent. It can always change. So it's not like kunyari, this particular year you get support of 50,000 a month from your husband. It's not something that is the legal order will continue, but the amount can change. Hindi siya in perpetuity.
Okay, so this is in relation to naman po sa sa amount na yung income ng other party, tama po ba?
Yes, and ability to pay. So I think that answers one of the question here. If he doesn't have money, the court will base the amount of support on the capability of the husband to provide the support in the first place.
Ayan, may follow-up po ako dun, attorney. For example, the husband already has, the partner before, the father of the child already has a family, his own family. And he's out of work, and then the only person who's generating income for the family is the wife. Now, he has a child with another woman. Paano po yun? Pwede po bang mag-demand doon sa wife ng husband? Or how to go about
This is support, This is not, that doesn't not always translate to vowsy, So this question that you're asking me, this is purely support, because you have to remember in vowsy there's a split, there's a deprivation, there is a if it's physical abuse or it's economic abuse, there's deprivation of what you are entitled to. So for you to be able, I'm sorry, because here's my, I have to just give a little background. What bothers me actually about the way some women have been using 9262 is that instead of going through regular proceedings as to support or custody in regular courts, sinasaksak agad nila ng vowsy, which for me is such a disservice, especially to the women who are really helpless, who really need it. I have women who work, who earn an income, but obviously hindi nila kaya to sustain the household by themselves, so they need help from their husband. Granted, you are entitled to that. But hindi siya dapat gamiting scapegoat yung vowsy, because may mga ibang babae talaga na walang-wala. Kailangan nila batas. Kaya ang nangyayari, nakaklag sa barangay, nakaklag sa court, kasi lahat na lang ng tao ginagamit yung vowsy. So in this instance, yung how do you establish vowsy? From this particular case, parang matagal na silang hiwalay. So is the abuse ongoing? You are entitled to support, but you have to honestly assess, is it abuse as defined under the law? Yun.
Okay, thank you so much, attorney. And then, ito po, meron second question. How does the law define rape inside marriage or dating relationship or yung
Sis Milo,
yes.
Sis Milo, ayun,
Yes.
para excuse me lang. So yung para makapagpahinga naman yung boses ni Attorney Ana,
Yes.
ang susunod naman natin nasasagot ni Attorney Cindy May.
Ay, okay.
Yes.
So, yes po. Attorney Cindy May, the next question is yours. How does the law define rape inside marriage or dating relationship, yung live-in po? And also may pahabol dito is gaslighting a part of psychological abuse.
So dun sa rape, no, kasi we have to understand that vowsy is a different law pa tackling for the abuse against the women, and the rape has another particular item pa sa ating penal laws. So we also have to understand that na yung rape kasi ano ba yung basic niya, hindi lang siya just abuse, it's doing something against you, against your consent, without your consent. So before, within the context of marriage, we had this notion, antiquated na siya actually, na once nagkasal na kayo, merong continuous consent. Kumbaga, you can't just turn back kasi part na siya ng responsibility mo. But with the advances also ng interpretation based also on the jurisprudence, now we nagkaroon na tayo ng mas clear understanding that even in the context of marriage, rape can still happen because consent has to be given on each and every act. So once pinipilit ka ng asawa mo na or partner mo na mag-penetrate, diba? And to have a sexual activity, and yet you don't want to, then that's sex without your consent already, and that might fall under rape already. So for the second question, is gaslighting a part of psychological abuse? Definitely. Kasi diba, gaslighting is parang it makes you question, di ba yung gaslighting, ako actually first time ko siyang narinig with the series na You. I don't know if you guys are familiar with that kay Joe. So what does gaslighting do to someone, diba? It makes you question your reality, makes you question na am I really hurt? I'm just making this up in my mind. So it will always tend to a psychological abuse kasi it will cause you emotional stress, psychological stress, and that's the basic premise sa punishable act natin with 9262 regarding psychological abuse. So definitely, gaslighting is one form of abuse.
Okay po. Thank you, attorney. And the next question is regarding stalking. When you file this kind of case, does it need an evidence? Is stalking on social media included?
I think yung major natin dapat premise natin whenever we want to file a case, it has to be proven through evidence. So definitely when we say na this person is stalking me, we have to back it up with evidence. So social media stalking, I think it will still fall under this under the common notion natin ng stalking as explained kanina ni attorney, no? Kasi yung stalking under the 9262, it's an intrusion to your privacy that makes you feel not just uncomfortable but makes you actually feel unsafe, diba? And if someone stalks you on social media, and that stalking on social media will actually translate also to other form of discomfort to you, na hindi lang naman syempre, kasi if the only form of stalking that we are talking about dito sa question na to, no, na social media is like us, alam mo yun, parang mindlessly looking at someone else's Instagram account, for example, it might be difficult to prove na there is already a feeling of unsafe, alam mo yun, parang unsafe ka na agad when someone stalks you on social media. So it has to go deeper than just being an usisero to your life, diba? So yun.
Ayan. So you really have to be...
Sorry. Can I add to that?
Yes.
Kasi if we should remember here that stalking is an example, but it falls under the umbrella of psychological abuse. So to attorney's point, it can be committed through stalking of social media, especially if, for instance, because the perpetrator was stalking the victim's social media account, he would text her, "Oh, so you're in BGC pala, ganyan. That is emotion, that is psychological abuse through the use of social media. So kung ano naman yan, if it's done quietly, tapos wala namang walang overt acts na ginawa yung perpetrator, then there's no way to show, in the first place, you wouldn't feel uncomfortable in the first place because you don't know what he's doing unless he communicates it to you. So, doon nagkakaroon ng evidence, doon nagiging psychological abuse.
Okay, so kung may actual na ginawa na talaga yung perpetrator. So,
otherwise, hindi mo naman malalaman.
Yes po.
Yeah, agree with what Attorney Cindy said kanina about ideally, you need to have evidence or documentary proof as to stalking in this particular instance. But remember, in the barangay level, hindi pa siya court, so hindi kasing strict yung rules of evidence doon since hindi pa siya judicial proceeding. So in instances like that, sometimes what I've encountered is even if you show your Facebook and you show the barangay official, hey, look at this is what happened, or I'll show you the text messages, they can consider that. Pero if you file it in court already, that's when what Attorney Cindy said, you need to have all these attachments in court. Also, what she mentioned as to also applies for live-in relationship. I saw the comment here. So even if it's a live-in relationship, what Attorney Cindy described will constitute rape also applies as long as it's under the act of Basi.
Okay, thank you po. So ayun, regarding the stalking on social media, you just have to be careful what you post. And turn off your location, di ba? Sometimes kasi automatic naka-turn on yung location and you don't know who's watching your be careful what you post. Yun lang po. Okay, and then the next one is since there is a pandemic, am I allowed to restrict the visitation of the father? Yan, siguro.
Since there is a pandemic, I think you raise the issue of health based also on existing IATF rules. You can say that I am restricting because I want you to be vaccinated, or I want you to be tested first, or I don't know where you've been. So in this case, I think you can raise that. You can restrict visitation because of fear for health. But if the husband or if the father complies with safety protocols, you cannot withhold his right, or you cannot keep that away from him, his right to visitation. And these are defenses, what I am stating. But technically, you have to distinguish visitation under regular proceedings and VAUC. Visitation under VAUC tends to be more limited because there's physical abuse or emotional abuse or psychological abuse. But if you're asking me this from a perspective of someone who is going through annulment or legal separation, you are bound by your judicial agreement as to visitation, even if there's a pandemic.
Okay, thank you po. So I think itong next question from Precious, when it comes to economic abuse, I think this was answered already earlier, yung sa financial support regardless of his situation. So it was answered already.
Yes po, thank you.
Okay. Okay. So the next question is regarding right to common property. Although it's not connected with Bausi, ang question niya po is, I am annulled, but division of properties was not done because my Mr. X doesn't want to talk about it. Can I, the wife, visit, stay? You still have the right of our conjugal property.
Okay. Full disclosure, I used to handle annulments, but since I became a Christian, I don't anymore. So I'm going to give it to you very generally. But if you're annulled, usually there's already judicial separation of property. It's nakadugtong yan dapat sa annulment. If it doesn't happen, you can still file for extrajudicial or even judicial petition for separation of your property if your ex wants to talk about it now. So there is nothing that prohibits you, since you said you're annulled na, so malamang there's a decree na. There's nothing that prohibits you from petitioning the court for separation of property, especially since your wife doesn't want to talk about it. And yes, can the wife say you still have the right of your conjugal property? It depends on the terms of your annulment. Kasi di ba when you file a petition for annulment, you were supposed to describe all your properties, real, personal, lahat ng kotse mo. It's supposed to be included in your petition. Okay? So when you say you actually have a decree, na the presumption is everything has been divided. If this hasn't happened, you go back to court and you ask that. If the petition was incomplete, it should not have been granted in the first place, or would not have been granted if it's incomplete. So your remedy will have to be judicial because there's already a decree. So for all intents and purposes, if it's annulment, the marriage doesn't exist anymore.
Okay, thank you po, attorney. And in relation to that, is the support for the common children covered na rin po ng decree ng annulment? Is that right?
Yes, usually it is. Pero like I said, support is ongoing. So even if my final decree for annulment na kayo, if a few years after you need to change or revise that, you can always go back to the court with respect to support, as long as the minor yung bata.
Okay, thank you po. The next question is, as a
Thank you.
Christian wife, you are physically abused and physically separated for security. What are the steps to reconcile, and when is it not possible anymore?
Okay.
Salimot
So,
ata ang question na to.
Okay. Sa reconciliation, kailangan nyo daw yung family ministry.
Family ministry. Okay.
Pero yung as to, yeah, I really recognize this something that Christian women will probably struggle with, if not uh, even from a theological perspective. But like I said, abuse is different. Enduring abuse is not tantamount to submission. What we learn about submitting to our husband doesn't mean submitting to his fist. That's an entirely different matter altogether. Because your husband also has the obligation to treat you like the bride of Christ, di ba? So when he does that, he's not doing something biblical anymore. And you are entitled to protect yourself. You are entitled to protect yourself and your child. But as to reconciliation, mahabang ibang usapan yan. So you can leave. You can leave. You can leave your house temporarily. You can leave your home temporarily. I'm not saying, and this is me talking as a Christian, not as a lawyer. You can leave your marriage temporarily for shelter. Flight. Like a flight talaga. You really have to get out. Working on your marriage, it will come. It will come after. It will come at a certain point. I don't advocate for annulment right away. But your first priority is safety. Even if Kristiyano ka, you have to stop the abuse. You have to stop enabling the abuse. So if you have to get out, you get out first. And then you focus on yourself, you focus on your relationship with God, you focus on your kids, tsaka na yung healing.
Okay, thank you, attorney. So, focus on yourself muna. Protect yourself and your child. That's the most important thing, lalo na pag physically abusive na talaga yung guy. Okay, so the next question is from another sister in Christ. So, can I file VAUC if my ex-partner for 11 years is not here in the Philippines? We share 2 kids together. He was abusive all throughout the 11 years of life we shared together. Abusive to our child, to me, and while I was pregnant. However, I don't have any evidences or pieces of evidence, but my son is traumatized and can remember his abuses to me and to me. sorry. Thank you. Up to now, my ex is still abusive mentally, psychologically, and emotionally. Thank you. Thank you, sis.
Yeah, this is what we mentioned, what I mentioned earlier. Even if it's a long distance relationship, you can still file for VAUC. My only concern here from the practical perspective is he said you don't have evidence. Pero if it's a long distance relationship, how did you maintain the relationship without communication? So if I were in your shoes, I'd look harder. Otherwise, your only other option is your child's testimony. And it is so traumatic. If traumatic what your kid went through, it's even more traumatic to ask a child to stand in public to testify as to what he saw. So I sympathize. I really do with what you're going through. LTR, hukay lang yan sis, may makikita ka niyang ebidensya. May makikita kang record yan. Kasi yung, kumbaga, if kasi kung yung anak lang yung magiging, kumbaga yung anak mo lang yung magsasalita as to the abuse, nako, kawawa naman. And also,
mas
8 years ago. And also don't forget the prescriptive period, So 10 years and 20 years. So check mo muna kung pasok pa.
Okay, thank you, attorney. And this is also in relation with, for example, the husband is already living abroad and he maintains a family, although they're not yet separated, right? You can file psychological abuse. Is that correct?
Yeah, for the marital infidelity.
Thank you po, attorney. And the next one is, kapag nasaktan mo ang asawa mo dahil ito, this is from a man. If you hurt your wife because you caught her in the act with another man, does it fall under VAUC?
Wait. Again, you hurt your wife?
Yeah. So,
Because the author's
fashion, ano to? Fashion?
no. In this case, it's not mousy. Because there was the reason, kumbaga, well, like, because there was there was no manipulation on the part of the husband. There was no threat. There was no intimidation. There was no force. There was no, di ba? Only four forms of abuse eh. Physical abuse, emotional abuse, psychological abuse, and what was the other one? Yeah, sexual abuse. So in this case, I don't see how it falls under any of the abuses. Pero I have actually encountered this because the problem with the law is it says any act or series of acts. So parang lumalabas kahit saan mo lang minsan na justified yung feeling mo, justified yung asawa mo, pwede ka pa rin kasuhan ng vowsy. In our case, it happened because my client was the guy. So, yeah, nakasuhan pa rin siya ng vowsy ng wife niya. So, it was really a matter of defense. In my opinion, it shouldn't be, but that's evidentiary na. It's up to you to prove that the elements of vowsy, the abuses based on vowsy and the acts defined in the law were not present. Pero if pwede kang makasuhan, yeah, ang vowsy pa rin.
Okay, so kailangan bago ka sumugod, videohan mo. Picture for my evidence. Ayun. Okay, thank you po, attorney. The next question is, I lived for 8 years with a man. He was unemployed and I supported him economically. We separated because he left for another woman. I had serious health issues because of the emotional and psychological effects. Can I still file a case? And what case will I file? Does vowsy apply? So, how long?
Okay. Just to narrow it down, since our topic is vowsy, if you're asking me based on these facts, you could file for vowsy. It will probably fall under either, since it's health, yeah, you can file emotional and psychological. If kunyari, I forgot to mention, pala, if you get a sexually transmitted disease through your husband, a sexual abuse, so that's grounds for vowsy. Yeah. And different for 8 years. So, again, prescriptive period, kasi sabi mo live for 8 years, is mukhang hindi na kayo. So, take out lang of the prescriptive periods. Yeah, you can still file a case for vowsy kasi it says ex-partners. So, former husbands, ex-partners, hindi kailangan existing yung relationship.
Ilang years yung attorney, prescriptive period?
Iba. So, balikan mo pa yung slide.
Oo nga eh. Nandun sa chart mo kanina.
Wait lang. We'll pull up the slide again. 18. There you go. So, if your grounds are psychological abuse, sexual abuse, mental or emotional abuse, 10 years. Physical abuse, economic abuse, 20 years. So, yung sa kanina, mukhang pasok pa.
Okay.
Thank you, attorney. So, regarding that, it's from the start, from the moment na nag-stop yung relationship, tama po ba?
Hindi, that's not necessarily. From when the acts were committed. So,
from when the acts were
kasi, like I said, pwedeng former dating relationship mo. So, pwedeng, ayun nga kasi hindi specify exactly. Kasi like other crimes, sasabihin from when the act was committed, ito nilagay lang nila 10 years. So, minsan lang nakikita ko, kinoconstrue nila na 10 years from the last act, or may nakikita rin ako na sinastart nila from the beginning.
Of the relationship.
Feeling ko, because the law itself was vague, ang dami tuloy wiggle room. Basta, for me, from the time it was committed, kung ongoing siya, para humaba yung period ng kliyente ko, yung last time.
Diba? Okay, yung the last
instance. Kasi yung sa first instance, rugi kami eh, diba? Pumapatak na yun.
Okay, so for example, halimbawa, 2010, let's say 2012, yung last na pananakit sa'yo. So, you can still file it up to 2000.
Separate yun. Separate action. So, kunyari, 2012, okay, sinaktan ka. Pero may gap. Tapos 2016, sinaktan ka ulit. Hindi yun dire-diretso yung count. Panibagong mag-count ka dun sa bagong act ng 2016. Get?
Okay.
Diba?
Okay,
Hindi
so,
siya ongoing.
yes. Okay, thank you so much, attorney, for that clarification. And the next one is from another gentleman. Are there laws for emotionally abused and physically abused husbands?
We can only hope so, but no.
No. Wala. Kulang kayo sa lobby. Like I told you, this Bausi Lot, itrabaho yan ng maraming babae. Eh, yung mga lalaki, hindi pa naglalabi eh. So, wala. Wala siyang equivalent law for men.
Actually, meron po, yung revised penal code. Diba? It's all-encompassing yung yung revised penal code, diba po? So, ayun. Doon na lang po
Everything is
kayo.
there.
Ayan.
Yun lang.
Okay, the next one is, the father of my son was married. Is valid to file VALC for financial support? Okay po. So, this one.
May nakita na ako magitong kaso, pero the thing is kasi, you're entitled to support for the illegitimate child, pero you have to remember kasi, and this is not even based on law, this is just based on what I have seen, yung relationship kasi is not, remembering definitions of VAUSI as your husband or common law wife, okay? So, ang presumption then is walang asawa yung lalaki. So, if the husband is already married and you're seeing him, you are actually committing a crime already. Diba? Kasi, pwede kang party to adultery. So, hindi pasok sa VAUSI. Gets? Pwede kang humingi ng support by all means, pero ang my right for VAUSI is the wife against you, not you against the wife.
Okay. So, speaking of tolerance, attorney, so if you know that your husband has another partner, and then you tolerated that, would you still be qualified for psychological abuse?
Yeah, yes. I mean, even if you, kasi yung tolerance is so subjective, di ba? So parang, if you establish that there was nothing you could do about it, that you've just learned to live with it and to accept it, he's still bound by his obligations of support, coming home to the, and this is family code, not VAUSI. Pwede may grounds pa rin. Hindi siya kasing clear-cut sa law on VAUSI, kasi, pero consent or agreeing to the relationship, hindi siya hindrance to filing a VAUSI case.
Okay, thank you, attorney. Yes. Okay.
Yeah, sorry, I just have one. The father of my son is about to transfer for. Yeah, you be careful lang, ha? Because like I said, yung mga, while you cannot be penalized for VAUSI for being the mistress, but you can be included in a petition for application for protection order to be filed by the wife. And if they establish conspiracy in a criminal court, pwede ka pa rin makasuhan ng conspiracy. So be careful lang. Kasi kung ako yung spouse or abogado ng spouse, ika-countersue kita. And siya yung may grounds. So be careful. I just also have to warn, kasi like 2 months ago, one of my closest friends went through this. And like I said, sa barangay level, one of the hardest things kasi about VAUSI is the implementation. And there are really, really good and really amazing barangay officials na talagang tatakbo sa bahay mo, susuportahan ka, who will be there for you. But in my experience, it's mostly the men. And sometimes you will have very tactless desk officials sa barangay. Na like what happened to my friend, when we went there, the woman at the desk, parang tinanong sa kanya, baka naman mainit lang yung ulo, pagbigyan mo na. And my friend who was in tears and so upset. So it's quite common to hear things like that. And you just have to remember that sometimes when they do that, it's because of our culture, lack of training on their part. You can always go to the head of their desk, complain, because they don't allow lawyers The law does not prohibit lawyers at the barangay level. The law only says you can have a non-lawyer advocate accompanying you. But in my experience, they will keep you outside, literally outside the door waiting. Kasi hindi ka pwedeng pumasok unless mapilit ka talaga na abogado kasi hindi siya prohibited sa batas. Pero marami talaga at na i-discourage yung ikaw or yung kaibigan mo or nanay mo. So you don't stand for it because it's their job to help you. And also you go to the women's desk, you go whoever is in charge of the policy desk. Another thing is sometimes they will tell you, they always get confused with respect to venue as to where to file. So, meron akong naging experience na we filed where the woman lived, pero pinagpipilitan ng barangay, kailangan i-serve dun sa opisina ng lalaki. Bakit? The law very clearly states that where the woman resides, di ba? It wasn't a workplace thing. So these little things, you will encounter it, lalo na kung wala kang kasamang abogado. So you just have to remember the law is very clear. May administrative penalty sila. Pag hindi nila sinundan, pwede natin i-report yan. So pagpilitan mo kung ano mo kung yung tama.
What age can a child decide which parent to go with? Does it matter if the child is legitimate or illegitimate to exercise this option?
Alright, sorry na just ako. If the husband has custody of the can the husband provide financial support?
Wait lang.
Lahat naman pwede. Ang tanong lang kung i-grant.
Wait, okay. What was the first one first? Sorry.
The question po is, what age can a child decide which parent to go with? Does it matter if the child is legitimate or illegitimate to exercise this option?
As to decision ng child, go ahead. Yung court yung nagde-determine based on the best interest of the child. It only becomes automatic when they're 7 and below, but it's also not automatic when they turn 8, they get to choose. The court will ask them if it's being contested by the parents as to the issue of custody. So what the law only provides is the 7 and below rule. But the law does not explicitly say that at a certain age, the child has the option to choose. So what happens is that it's always a case-to-case basis. Dinidetermine ng court, depende sa relationship ng mag-asawa or soon-to-be ex sa mag-asawa. They ask the child, they ask the case study worker. So hindi siya fixed age yung choice. Yun.
Thank you, attorney. And may nag-raise po ng hand, si Sis Jen. Sis Jen, can you unmute yourself? Yes.
Yeah. Good afternoon, attorney. May question na po ako.
Okay.
Itong process po, kasi po, nag-file po ako ng vowsy po dati, 2017 sa NBI. Sa po. And then, dumaan po ako sa mga process, psychological exam, interview nung doctor. Then at the end, sinabi po niya na hindi raw po ako fit mag-file ng vows. Dahil interview sa kaya ano raw, mag-concentrate daw ako sa isang case na lang na pinafile.
Yeah, okay. When you filed the vowsy that you filed was independent action or it was an incident to another case that you filed? Kasi kasi usually sa vowsy walang counseling, pero you said you went through an assessment, so I'm assuming this was an incident to another case, hindi siya independent na vowsy?
May related rin po sa isang case po.
That's why, that's the difference. Because in vows, I knew right away when you said it na hindi lang vowsy yung final mo. Kasi pagka pure vowsy, for lack of a better word, sorry, wala siyang assessment. Wala siyang counseling. Get? So, hindi, obviously it's in the barangay level or even the court level, hindi ka nila pagdadaanan sa counseling or sa assessment kung may grounds ka. So, if you told me that there was an assessment made pa, that means this is an incident to another case. So, hindi kita ma-advise on fully niyan because I don't know the details of the other case.
Thank you po, attorney.
But there's nothing that's stopping you from filing vowsy naman again. So if the grounds are still there and it's not yet prescribed, pwede ka pa naman mag-file independent from this other case that you're talking about.
Kasi parang
Assuming,
na-frustrate na po
wala
ako
na,
nun.
ha?
Kasi
Ha?
parang na-frustrate po ako that time kasi parang kumbaga back up ko po yung parang gusto ko pong, kasi yung other case regarding sa daughter ko, gusto kong i-out yung daughter ko. Kasi parang advice rin po sa akin, yun din, sa CCF Law Ministry rin po siya na parang kami yung maglalaban. Hindi ko muna, kasi minor pa yung ko parang hindi ko siya iaano muna sa trial. Kasi parang, yun nga, dahil minor, makikita, parang malalaman niya, babalik na naman sa So, yun nga po ang parang plan nun, mag-file ng vowsy, parang backup. Kaso nga po na dininay po ng NBI. Kasi yung mga interview po sa akin, yung parang parang yung mga, kung may work ka, kunyari yung mga support group, parang ang assessment po nila na parang I can stand naman daw na hindi raw pasok sa vowsy.
Can I answer, Ana?
Yeah.
Okay. Si NBI lang naman po nagsabi niyan, pero hindi naman po 'yun magpo-prohibit sa inyo na subukan gawin pa rin 'yun. So you can go through the remedies again, you can go through the barangay, or you can file a direct action in court. Kasi naman po yung kung napansin niyo po yung presentation ni Ana kanina, wala naman po nakasulat doon na NBI. So porket sinabi ng NBI na hindi pwede, hindi ka na pinipigilan. Kumbaga hindi ka nawawalan ng remedy to proceed with the filing. File nyo na lang. File nyo na lang.
Opo. Yun lang po. Kasi medyo naguluhan lang po ako that time eh. Kaya parang yun, kinaklarify ko lang po.
Yes po, Attorney James.
Ayun, sundan ko yung sinabi ni Attorney Paulo. With respect doon sa pagpunta sa NBI, meron na tayong NBI Modernization Law na dinidistinguish lang ng batas kung ano yung jurisdiction ni NBI. And sa bagong batas, sa NBI Modernization Law, hindi na kasama yung vowsy cases na pwedeng asikasuhin ni NBI. So pag pumunta kayo ngayon sa NBI regarding vowsy cases, talagang hindi na kayo i-entertain. So wag na kayo pumunta ng NBI na.
Wag na mag-NBI, mas matagal.
Barangay na muna.
Barangay, mas
Okay.
Salamat po. Thank you po for answering my question.
Okay. Thank you po. So, attorney, sasagutin mo ba itong tanong ni Bro GP if the husband has the custody of the children? Okay, so next po. Next. Yes, Attorney Paulo.
Lahat naman pwede gawin. Ang tanong kung i-grant. So, syempre, kailangan natin malaman yung facts muna kung kunwari siya pa yung breadwinner, yung wife pa yung breadwinner, etc. etc. So, it's not something that can be easily answered in this forum. But again, like I said kanina, lahat naman pwedeng subukan until i-deny.
Opo. Thank you, Attorney. Ito pa, next question is, my daughter is already 21 years old, still studying. Can we still demand for a financial support, especially for her schooling? Fathers not giving regularly and consistently.
As a general rule kasi, yung support, even if hindi na minor yung bata, pwede pa rin magbigay. Pero minsan kasi nililimit ng courts, lalo na kung tapos na dapat mag-college, kasi hinihingi support for FA. Well, in this case, hindi, support doesn't stop at 18, So, even minor child siya, pero kung hindi pa tapos mag-aral yung bata, and lahat naman ng college, hindi naman natatapos ng college ng 18, di ba? So, pag pwede pa rin humingi ng support. Yeah. Kung doesn't give regularly and consistently, well, hindi siya automatic vowsy, because kulang yung support. So, again, distinguish yung cases ng vowsy, withholding of support because merong purpose, because behind it, as defined yung sa acts, as to actual not giving regularly and consistently, it doesn't automatically mean vowsy yun. Tapos, yeah, yung sa ex-husband, my ex-partner was annulled while we were together, but I was abusive all throughout the relationship. Like I said kanina, you can, kasi what happened with us in this case is we were representing the wife, and the mistress filed for vowsy against the husband, the boyfriend niya. So you can do that, sure. Kasi kahit na married siya, like I said, ex-relationship, former partner. Pero when you file kasi a vowsy case against someone, because you were the mistress, there's an admission that you were the mistress. And what we did, we used this admission against the mistress in her vowsy case. Yung kanyang mga statements, mga public statements siya na adultery, na complicit siya sa adultery ng asawa. So be careful. Be careful lang. Kasi, be careful. Just make sure na hindi vindictive yung babae, yung wife, na hindi ka maka-counter sue for whatever action that you take. Sure, you can file vowsy, sure. Pero, remember, when you do, these things become public documents. You admit to an illicit relationship, and these may be used against you. So yun lang. By all means, you can, sure. Pero the wife, especially if hindi amicable yung pagkakahiwalay nila, can also use these things against you. Yun lang. Ay, saka word of warning pala, as to yung what they mentioned kanina, when you file a vowsy case, and I mentioned kanina, it really, really frustrates me how women tend to use this a lot, especially in support cases. They will file vowsy because they want more from their husband. They will file vowsy because hindi enough, or dahil sa support, nakuha. May mga ganong cases eh. So, women have abused this law repeatedly. Repeatedly talaga. It's not fair. It's such an injustice to the women who really need it. And a word of warning is, if you reconcile in the middle of your vowsy, ang sabi sa akin ito, judge, he told me, attorney, you better talk to your client. Gusto na siya magsalita. If she's sure. Because if she's not sure, maawa siya, balikan niya yan, makikita nung lalaki, uulitin lang yan. So, if you have a friend and it's physical abuse especially, and they want to file physical abuse based on vowsy, it's going to be stressful. It's an out-and-out fight, and she better stand her ground. She better stick to it, because if she doesn't, maawa siya, bumalik. The guy will think, oh, I can do this again. Tingnan mo, binarangay na nga ako, na-BPO na ako, pero binalikan pa rin ako. Ay, maulit nga. So, dapat may conviction ka na. So, don't treat it, I always tell you, don't treat this law lightly. It's fast, it's a swift law, mabilis yung remedy, pero sigurado ka, buong-buo ka loob mo emotionally, physically, so itutuloy mo yan. Kung hindi mauulit ang yung abuse. So, yun. Something to remember, guys, for your friends.